Hello, everybody. Thank you for being with us today. Very good weather here in Austin. Thank you for joining. Today we have a very great presentation with Allison Schaberg from Consolidated Planning Group and with Allison Packard from Packard firm. She's a special needs attorney. Thank you guys for being here with us and sharing your information with our audience. But first, before we start our presentation, I'm going to talk about Partner Resource Network. My name is Veronica Alvarez, and I'm the Regional 13 Coordinator for Partners Resource Network. Partner Resource Network is the parent training and information centers for Texas, as you can sometimes hear us as the PTI of Texas. And we are funded by the Department of Education, Office of Special Education, OSEP. And we provide free resources and help for parents of children with disabilities and young adults with disabilities that we call them self-advocates. Our mission is to empower and support Texas families and individuals impacted with disabilities or special healthcare needs. We serve parents of children with disabilities and youth with disabilities from the ages of 0 to 26 years old. Partner Resource Network was first founded in 1986, and now we have 4 projects serving parents and youth with disabilities here in Texas. We have the PAT, the TEAM, the PEN, and the PACT project. And I'm part of the TEAM project. As you can see in the map is the red area. So I'm the Region 13 that is in Austin. And then we have Region 20 that is San Antonio, and Region 1 that is all the South Texas, Rio Grande Valley area. But if you are at another area in Texas, we have a coordinator near you. We have 20 of us across Texas. If you don't know who your regional coordinator is, please just send me a text or put it in the chat box or an email me, and I can put you in contact with your regional coordinator near you. Our services are free, and we offer parent workshops, we do the workshops, webinars, informational referrals, one-on-one technical assistance, support in the ART meetings, in the IEP meetings. We do once a year a symposium, each coordinator. So we have 20 around Texas a year. And we offer also parent leadership trainings, youth leadership trainings, and access to social media resources. So for today, your video and your audio is muted, is closed. So if you have any question, please type it in the chat box in the Q&A, and Allison and myself, we are going to be monitoring your questions, and Allison Packard is going to be helping us answer those questions. And later today, or more realistic, later tomorrow, we are going to share the link of this recording in our Facebook pages. And also Allison Schaberg is going to share a link for their YouTube channel. They also post all the videos in their YouTube channel that they have. Please help us with that. At the end of this session, you are going to receive an email with a survey that's an evaluation of today's webinar. And we really appreciate if you can fill out that information and provide us your feedback. With that, we report to our grant and continue providing you guys with free webinars and resources and everything. So for today, we do not, sorry, it went, go back. We do not provide CEUs, but if you need a certificate of attendance, I can do one for you. Just type it in the chat box or email me, and I can give you a certificate of attendance. Again, my name is Veronica Alvarez, and you can see there is my phone number and my email. Also, I put it in the chat box if you need it. And please visit our main webpage, at www.prntexas.org. We have a lot of information about disabilities events, everything related to special needs. All right, I'm going to stop sharing my screen. And now we are going to listen the presentation, Guardianship and Alternatives, with Alison Schaberg from Consolidated Planning Group. She is a financial planner and a funder of the company CPG, and she has a lot of experience working with families with special needs. And also we have Allison Packard. She's a special needs lawyer, and she's the one that is going to be talking to us about guardianship and alternatives. So thank you, both Allisons, for being here with us.
Thank you.
Thank you for having us. I'm having just a little bit of technical difficulty. It's just trying to reopen, so just bear with me. So Allison Schaberg here. Thanks for joining us again, Veronica. It is always our pleasure to be back with you, and we love the education and support that you are putting out for families with kids with disabilities, for sure. So Consolidated Planning Group, we are a holistic special needs planning firm. We are located in Sugar Land, Texas, and we actually work with families all across the U.S., not just in Texas. So, so we are nationally certified as Social Security advisors, and we are also members of the Special Needs Planning Academy. So we're really well versed in helping families determine future care cost estimates, when and how to pull the trigger on Social Security benefits, navigating all of those difficult conversations, SSI and Medicaid, and how not to lose those benefits. So we're definitely here to help you in that regard. But so I'm happy to be back with Allison Packard. Allison and I, it's all in the name, I say, but Allison and I sat on the Texas Partners for Policy Making. We were on that task force together, and that's how we came to know each other much better. We spent many hours on that as really advocates in the special needs community. And Allison and I both share the fact that we have a child or children with special needs, so we understand the journey for sure. So having said that, can everybody see my screen okay? Veronica, are you seeing that now?
Yes.
Okay, sorry for that little bit of difficulty, but I think we're all set. And so Allison, thank you again for being with us. This topic of guardianship and the alternatives to guardianship is a big deal. It's a big deal. It's an emotional roller coaster thinking about this, and what are you doing or what are you not doing by taking action or not taking action. So I'm so glad that you're here with us, and you're gonna kind of share what we need to know about this. So I'm gonna turn it over to you.
Okay, great. Thank you. I really appreciate the invitation, and it's a pleasure to speak to everyone. Let me just say at the outset, we got to go kind of fast. We just have an hour. So if you have any questions, follow-up questions that we don't get to, feel free to email me, but otherwise Allison will interrupt me as we have questions throughout this hour, and that's just fine with me. So guardianship, what is it? It is a court determination of incapacity. So when we talk about whether or not somebody needs a guardianship, it's not just a simple thing. It is going to court, having a judge evaluate your child and decide if a guardianship is needed. Now, you have options. You don't have to go to court and have a guardianship for your child. You could let your child just continue to sign their own documents and manage life on their own. And many children with disabilities are able to do that to some extent. But I think for most of us who are on this call, our children, even when they're adults, are going to need some support. And so we could possibly look at a less restrictive alternative from a guardianship. If we need the guardianship, that is appropriate if our children don't have the capacity to sign powers of attorney and make a lot of decisions on their own. And we'll get into some of those less restrictive alternatives in a minute. But again, you know, if we go to the guardianship court, what we're doing is we're asking a judge to make a finding of an incapacitated adult person. And what that is, someone is found to be incapacitated if they can't substantially provide for themselves because of their mental incapacity or their physical incapacity. And then the second part of a guardianship hearing, after the judge has determined that someone is incapacitated, is determining who the right guardian is. So that's pretty much what the hearing is about and what the guardianship program is.
Allison, can we just talk about the question of on whether or not they can sign a power of attorney and a healthcare power of attorney, because there's a lot of questions surrounding that. Like is there a line in the sand of a person's ability to understand what they're signing if they were going with a power of attorney or healthcare power of attorney? Is there a magic IQ score that if it's below that maybe we should be scratching our head on this? Can you talk about that?
Sure, that's a great question, and probably one of the toughest questions in this area. I would say if your child has been determined to be intellectually disabled so that they have an IQ score below 70, you probably will not be able to have them sign a power of attorney. At least most lawyers are not comfortable with that because they have been found to have an intellectual disability, meaning they wouldn't understand the legal document. Now, that's not necessarily a fixed line in the sand. There are clearly some people with lower IQs who, are much brighter and can read and do some things, but that's what a lot of lawyers will say. Just because your child has an IQ above 70, though, does not necessarily mean that they will understand that power of attorney. So it really is individual by individual. When I have someone who is very borderline capacity, I will spend some time with them, have them read with me, talk to them. But if your child could not independently, without you there in the room, explain generally what they're reading, answer questions about who they want to be their power of attorney agent, who they want as a backup, if they can't have that conversation, they may not have the ability to sign a power of attorney. Now, let me just add one more thing, though. There is a supported decision-making agreement. The capacity for that document is a little lower. It's a much simpler document. It's not very difficult to understand, but I caution parents about relying only on that document. A supported decision-making agreement means that you are acting as a supporter for your child, but you don't have the ability to make decisions for your child. So I like supported decision-making agreements, but I like them coupled with a power of attorney as a backup. Great questions.
Thank you for that. And we had one more, and I think you're probably going to get to this by the medical statement. What if we're trying to file for guardianship and we do not have a doctor that is willing to sign off on this medical statement? What happens? Do you just keep going from doctor to doctor to try to get somebody to sign off on this?
Yes, you're not going to be able to get a guardianship without that evidence. It's called a certificate of medical examination, and it is a crucial piece of evidence that needs to be submitted to the court. The judge is going to read that in great detail. If you don't have this form filled out by a doctor, it needs to be a doctor licensed in Texas, needs to be an actual medical doctor, not a physician's assistant or a nurse practitioner, not a psychologist, but a psychiatrist, a neurologist, a primary care physician. Any of those are fine, but you do need this form completed. In this physician's form, we call it a CME for short. In the CME, the doctor is going to specify what your child can do. Could they make decisions about marriage? Could they vote? Could they drive? Could they make their own medical decisions? And depending on what the doctor puts on that question number 5, it's on the slide, a little bit small print, but depending on how the doctor answers this, that will determine whether or not you have a full guardianship or a total guardianship or a limited guardianship or partial guardianship. So for example, if a doctor were to say, this person cannot make decisions about marriage, they can't drive, they can't consent to their medical treatment, but I really think they can vote. They want to vote, voting is important to them. Then what we could do is apply for a guardianship with limited authority. And that means that the individual who's going to be under a guardianship could retain some rights, in this case, the right to vote.
So as a best practice, we've pretty much understood that, a doctor that you've had the most history with is probably the first physician that you should go to have signed this. But I think in the more recent years, we've been seeing more physicians that are reticent to sign this because it's such a big deal. And probably doctors that are kind of on the fence on this is some of these kids that are on the fence, high functioning autism or some of the other areas where they're not there yet. So if that's if we've got families on here that's their issue. So I get that a doctor has to sign off on this. I mean, what do you recommend in that at that point? I mean, for all we know, doctors are going to CE courses and they're telling them don't ever sign a guardianship form, don't ever sign the CME. I mean, we don't know that. So tell us what do we do in that regard, and our child truly does need guardianship.
So my experience has been, if your child clearly needs a guardianship, you won't have a problem getting a doctor to sign that. Now, maybe I'm mistaken, but we get these in many every week. And so I think if there's an obvious need for a guardianship, if your doctor is reticent, just use another doctor. There are doctors in my area out here in San Antonio that just do evaluations, typically for elderly people who aren't seeing doctors regularly and don't have the capacity to set up the appointment. But you certainly could get a doctor that your child's not familiar with, but it wouldn't be ideal. Ideally, you want to go to the doctor that knows your now adult child or soon to be adult child, because they're going to be able to answer all those questions. The reticence for signing these forms is really coming from a good place. When you have a guardianship, you are losing a lot of rights. Anyone under a guardianship, if it's a full guardianship, they no longer have a right to drive or get married or make medical decisions and vote. So those are basic civil rights. And so we don't want to just take those away without a lot of consideration. And so it might be, if your doctor is uncomfortable signing that form, perhaps a limited guardianship or maybe even an alternative to the guardianship might be worth considering. That might be why the doctor is a little uncomfortable signing it. And let me comment, when I say you remove the rights from the person, it is possible to restore some of those rights, but it's difficult. So I'll give you an example. If your child is under a guardianship and they no longer have the right to get married, and then 10 years down the road, you have decided this is a great idea for your child to get married, your child's in love and you're very supportive, you could go back to the court, you could explain the situation, ask the court to restore that particular right. I'm sure the judge would run a criminal background check on the person who wants to marry your child and would also explain the financial implications, but it is possible to have rights restored, but it is a difficult process. It involves a new physician CME, more court hearings, more attorneys involved. So it's not something you can just casually change back and forth.
Miss Allison, if we have had two CMEs and they're different, like the pediatrician, and then we have the neurologist, and one said full guardianship and the other one leave them blank. Sometimes they don't fill all the squares. Is this a problem for to obtaining guardianship when we have, in a case like that?
Yeah, great question. Before I will file a guardianship application, I'll look at the CME, and that's just my practice because I don't want to file for a guardianship unless we can get a guardianship approved. So if you have one doctor who hasn't filled out the form completely, checked all the boxes, obviously that wouldn't be a great form to use. But you only need one CME. Some people file more than one just as extra evidence, but really that one physician's certificate is going to be enough medical evidence to get your child a guardianship, as long as it's very clear on the medical form. Great question. Let me clarify that there is a guardianship of the person and guardianship of the estate. This is sometimes a little confusing. Guardianship of the person is when you as a guardian have the right to make medical decisions, to choose where your child lives, but it's not managing money. If you want to manage your child's money, that is guardianship of the estate. Now, we talked about needing to see if there's a less restrictive alternative, and I would submit for most people on this call, we could probably avoid the guardianship of the estate by using less restrictive alternatives. And what I mean by that is you can find other ways to manage your child's money. So for example, if your child is receiving SSI or SSDI, you could become a representative payee in the Social Security system. And then you would have the authority to, it's kind of like a guardian for Social Security funds. So you could manage money that way. You could have a special needs trust set up and appoint a trustee who would manage the money in the special needs trust. And so typically we can avoid the guardianship of the estate by finding other ways to manage money. And that is often a good decision because a guardianship of the estate requires an annual accounting, which must be done by an attorney. Whereas a guardianship of the person, once you have that guardianship, it just requires a simple report every year. And we don't need to involve attorneys. So a lot of times we do try to avoid the guardianship of the estate, but it is important to know that, if you don't have a guardianship of the estate, you may not be able to go open up a bank account unless you're a representative payee for Social Security funds.
I had something come up this last week with a client who was told by the Social Security Administration that they couldn't be the representative payee because they didn't have guardianship. So how do you address that? Hang up and call back?
Yeah.
So I mean, like, that's not anything I've ever heard to be true, but they were definitively told that they basically, and then we've seen this, like with, again, higher functioning autism, some of the impulsivity, disabilities, ADHD and things like that, where they simply cannot manage money. They may not need guardianship, but they simply have the inability to manage money. So, tell us what to do on that when you're being told you have to have guardianship to be able to be the representative payee.
In that situation, I would talk to a manager or talk to someone else. That's clearly not true. You do not need to be a guardian to be a representative payee. I know many, many, many people in that situation, myself included. I am my daughter's representative payee. I'm not her guardian. So that's just maybe a new caseworker, and Social Security Administration has a lot of turnover. And even though we're so familiar with these issues, a lot of the workers don't deal with disability situations like our children. So it might be something they're just not aware of, but definitely go back because you can be a representative payee without being a guardian.
Thank you.
Okay, let's talk a little bit more about this reform in Texas. This is something relatively new in the last few years. We want to make sure that we're not getting guardianships too quickly. We want to make sure there's not a less restrictive alternative. So at the court hearing and in the court paperwork, we need to address this issue of less restrictive alternatives. Have you thought about alternatives to the guardianship? And so some of the most common alternatives to the guardianship that we would think about to see if we could avoid the guardianship would be powers of attorney. That's the obvious one. If your child has the capacity to sign a power of attorney, that may completely avoid the need for the guardianship of the person. They could sign a medical power of attorney, a general durable power of attorney, either the statutory form or a simplified version. They could sign a supported decision-making agreement. There's some other documents for mental health treatment. But something important to remember on these documents is that they've got to have capacity to sign that. So in other words, you cannot just take a medical power of attorney and put it in front of your child and say, please sign this. Here's your durable power of attorney, please sign this. We all know our kids will sign what we tell them to sign, but if they don't understand what they're signing, that is a legally invalid document. Do people do it all the time? Yes. Does it work sometimes? Yes, sometimes schools or other individuals or agencies just take it without questioning, but they don't have to. And if it came down to it, it probably would be considered invalid if your child didn't have the capacity when they signed it. Okay.
Two things, Allison. I want to chime in here. For all of you that are on here that have other children that are neurotypical children that might be going off to college, I suggest that it's a good idea to have that power of attorney and medical power of attorney for our kids that are going away to college. I think it's a good practice because I have seen, clients over the years where, the kids, got hurt. There was a car accident, there was a fire, there's some different things, and those documents weren't in place and it became difficult. Definitely almost impossible if your child has a mental health break and they're in a psych ward somewhere and there's no documents in place. They're definitely not going to talk to you. So I want to mention that, and on the same vein, it's also important to have these conversations with any aging parents in our life too, to ask them, do they have these documents in place? Have they looked at them in the last 15 years? Because we don't want to wait until the crisis happens and find out that that those things aren't in place. The very last thing I wanted to mention on the power of attorney and the healthcare power of attorney is where this can be problematic is if you have an adversarial child that is angry and aggressive and, falls out of love with you every other day. And, they have the right to revoke that power of attorney at any point. So talk to us about that, Allison, because I know some families that is something that they deal with on a pretty regular basis.
Yeah, that's a great point. If you're telling your child to sign a medical power of attorney and you're suggesting that your child has the capacity to sign that, then your child, now an adult, can have the capacity to revoke that and change their mind and maybe appoint their girlfriend as their power of attorney agent or somebody they just met as their power of attorney agent. And by having your child sign that to begin with, you're suggesting they have capacity. So if it hasn't changed, it's a difficult argument to say that the new power of attorney is not valid. However, when there's lots of problems, adult children revoking, re-signing, revoking, sometimes we can use that as evidence with the court why we need a guardianship, because we've tried a less restrictive alternative with such as a power of attorney, and they are just not managing it well. They're making poor decisions, and we can show the court what has happened. But that is certainly something to be concerned about. And by the way, on the medical power of attorney, just to be clear, medical power of attorney does not kick in until a doctor determines the person to be incapacitated. So if your child signs a medical power of attorney, that does not mean that you now can make medical decisions for your child. And by the way, when I say child, we're talking adult children at this point. Obviously, we make medical decisions for our minor children. But once they're adults, what the medical power of attorney would do is tell the doctor who will kick in and start making those decisions if the adult child becomes incapacitated. So that's where a supported decision-making agreement coupled with that medical power of attorney might be really useful, because even though our children might not be completely incapacitated, they will need support, maybe explaining what they want to the doctor, understanding what the choices are, just general communication. And a supported decision-making agreement is excellent in that situation where our kids could make their own medical decisions, but need a lot of support. The other type of durable power of attorney, this is just the general power of attorney, all decisions other than medical decisions. And this type of power of attorney, we can decide whether it's effective the moment we sign it or only if a doctor says it's effective only if a doctor says we're incapacitated. So we have a choice there, whether or not it's effective immediately. And I wholeheartedly agree with everything Allison was just saying about, college kids and elderly people. Remember, if there's a power of attorney that we can use, it avoids a guardianship. And that works not just for our children, but for our parents and grandparents as they age. And so having these documents in place can save a lot of hassle and expense in the guardianship court. Okay, let me keep going unless there are other questions. All right, I'm going to skip down to talking a little bit more about the supported decision-making agreement, just briefly. The supported decision-making agreement is a new, well, relatively new. In the last few years, 2015, I guess that's not as new as it used to be, but Texas was the first state to have supported decision-making agreements. And this is spreading across the country. The theory is that we don't want to take rights away from adult children with disabilities if we don't need to. And decision-making is a learned skill that requires practice. And so let's let our children try to make their own decisions and give them support. If someone has a supported decision-making agreement, what they do is they appoint a supporter to help make decisions. You don't have to go to court. The person who's signing does need capacity to understand what they're signing, but it's a very simple document. And Allison, I don't know if you can skip a couple slides forward to the actual language. We'll go one more if you don't mind. The language is very simple, as you can see. My supporter can help me with life decisions about obtaining food, clothing, and a place to live, my physical health. You can see how simple this document is. But again, I want to just emphasize, while I really like these documents, I've used them, I think they're very effective in certain situations, I would not be comfortable relying only on a supported decision-making agreement. Because if your child did lose their capacity, say they needed surgery, say they needed something where they were unable to make their own decisions, you don't have a backup here. So either I would do a supported decision-making agreement with a power of attorney backing it up, that would kick in upon their incapacity, or just a power of attorney to begin with. Hope that made sense. Let's talk a little bit about guardianship of the estate. We mentioned this is the guardianship where you will be managing your child's money. We want to try to avoid this if we can because of the cost. If you have a guardianship of the estate, you need to hire a lawyer every year to do an accounting. So guardianship of the person, just a simple report, doesn't need a lawyer to be involved. Guardianship of the estate, you're going to have an attorney's fees every year. So again, less restrictive alternatives for guardianship of the estate would be that same supported decision-making agreement we've been talking about, signing the durable power of attorney to manage finances, becoming a representative payee, we've talked about that in the Social Security system, or having a special needs trust or another trust, and appointing a trustee to manage the funds. And this could be a completely another hour's worth of topic on special needs trust, but let me just generally say what the trust is it separates the equitable interest in the trust from the legal interest. I didn't explain it very well. Basically, for a trust, you have one person who owns the property for the benefit of a beneficiary. So I could be the trustee for my daughter, which means all the funds in that trust must be spent on my daughter, but I'm the one managing it. So it kind of separates those two roles. And a special needs trust is a certain kind of trust only for someone who is disabled. And those are really critical trusts for those of us who have kids with serious disabilities, especially if our children are going to be receive government benefits over their lifetime. Very important. Do we have, Allison, I see we're on the slide, representative payee. Are there any other questions about that? I will note that Social Security Administration has their own system, so they don't accept powers of attorney. They don't care about your powers of attorney. They want you to use their system. They will take your guardianship letters, but they will still make you become a representative payee. So you can't go to them and say, well, I have rights, I'm the POA, and they'll say that's not what we use.
Yeah, that is a big thing, and I think people get told that every week and they're shocked. They just have their own forms. There's a form, SSA 3288 form, that you can download right from the internet, and you can have it filled out and your kids sign it. Like if there's not guardianship in place, where it will give you authorization to call on their behalf, because most 18-year-olds, and especially 18-year-olds with disabilities, most adults don't have the capacity to understand all of the nuances with the Social Security Administration, because it is horrible. So if it has felt painful to you, you're certainly not alone there. But that 3288 form, absent a guardianship, will allow you to call. Of course, if you're the representative payee, then they'll have you listed that way. But if you're not the representative payee and your child is going to be paid directly their SSI, you still can be on their account to call on their behalf under that 3288 form.
That's great advice. And one other thing to note is if your child is in the system, Social Security system, as needing a representative payee, and the representative payee passes away or can no longer serve, that a lot of times will lead to money being frozen until the new representative payee is appointed. So for people who are aging and maybe know that their lifetime is limited, there are some things you can do to make sure that a new representative payee is appointed. So you should talk to the Social Security Administration so that the benefits don't just stop and be held if the representative payee is no longer living. Okay, let's go on a little more about the trust, the special needs trust. We mentioned that. I just do want to make sure everyone understands that there's two types of special needs trusts. One type of special needs trust has a Medicaid payback on it, which means when the beneficiary of the trust dies, whatever is left in that trust will go to pay back Medicaid for benefits they've paid for the person's entire lifetime. So we don't like to use those kinds of trusts if we can avoid it. Instead, we'd rather use a third-party special needs trust. That's the one without the Medicaid payback. But if the money is already in the name of the person with a disability, that's the only option we have, is the first-party trust. I wish we could go into more detail. We just don't have time. But if you're unfamiliar with special needs trusts, I would research them a little bit, send me an email and I can send you some things to read. Allison's very familiar with this. But it is important to understand the differences, because you as a, all of us as parents of children with special needs, we need to make sure our estate plans are in place, because we could inadvertently disqualify benefits for our children by leaving assets to them in their name. And even though it can be fixed, sometimes we end up with the trust with the Medicaid payback, and it's just important to do that estate planning early.
We have a question that says, can we go back on the question on the POA? My understanding is that a parent with a POA, I could receive information on my son or daughter without having them to be incompetent. So yeah, it is the case, except for with the Social Security Administration. They have their own set of rules. So yeah, you're basically right, except for the Social Security Administration, right?
That's right. Social Security Administration, they just have their own world, their own rules, like you said. So while you could take your power of attorney into a bank, and if it was effective immediately, you could spend the money, you could manage those funds, you could sign leases and gym memberships and talk to different people. That works in most areas. It's just the Social Security Administration has their own system.
For sure, for sure. And then one other comment, we talked about our YouTube channel. We put that in the chat box. We have entire presentations dedicated to first party and third party special needs trust. It is confusing, and it's not just as simple as saying, I only want the third party special needs trust. The third party special needs trust is best because there's not a Medicaid payback, and we can leave our life insurance proceeds to a third party special needs trust so there's no Medicaid payback. We can leave assets to that third party special needs trust. But what I just want to be clear is that first party special needs trust, sometimes it can't be avoided. Sometimes there was a lawsuit, there was a settlement, there was a family member that accidentally left money to your child outright as opposed to the third party special needs trust. In my child's example, there were refunds from college coming in that were her money. So we had to have a special needs trust in that example for those dollars. So, but again, you guys can check out the YouTube channel or certainly reach out to Allison directly. Some families will need both. Some attorneys set up both automatically. Some attorneys gravitate more towards the third party, and then we'll set up the first party later if you need it. And I don't think that there's a right or wrong, way of doing it. I think it's just a matter of practice management when it comes to attorneys. You want to comment on that, Allison?
Yeah, I think those are great points. I would add to the list of first party trust, if you have a military survivor benefit annuity plan and that SBP is going to pay to your child, that has to go to a first party trust as opposed to third party trust by law. If you have child support for an adult disabled child and you want that child support to go to the trust so it doesn't reduce SSI benefits or eliminate SSI benefits, that child support has to go to a first party trust. So I agree that there are just certain things, the car accident settlements, all kinds of different things where we have no choice but use a first party trust. Otherwise, as long as you're planning ahead, you can decide where you're going to leave your assets. And with advanced planning, you can leave as much as possible to the third party trust. That way you're in control of where the remaining funds will go when the child with disabilities dies. And again, remember, this is for a special needs trust, which is only available to someone with disabilities. And I just say that because I always have people call me and say, I want to set up a special needs trust so I can keep Medicaid. And I say, what are your disabilities? And they just don't have disabilities. They're just not a lot of money and they don't want to lose their benefits. This is for a special kind of trust for individuals with special needs.
One other thing, because we had another question in the chat box on beneficiaries, and that's something, if you've attended our webinars in the past, almost every webinar I talk about beneficiary designations. And the bottom line is, again, we have webinars on all of this. But what a lot of people do, they name their spouses as the primary beneficiary, and then they name the contingent or the secondary beneficiary. That's easy. My kids will split it however many ways, however many kids you have. And then they name their kids outright as the contingent. If you've done that, it's wrong, but you can fix it. And you can fix it for free by, getting a change of beneficiary form. But when you name your special needs loved one directly as a beneficiary, that money's coming directly to them. And unless it gets moved to a first party special needs trust, they're going to basically have too much money to qualify for the means-based test with SSI for SSI and Medicaid. So that's why we don't want to do that. So the right way to do it is to leave it to the third party special needs trust for the benefit of said child. The other thing that a lot of people do is they name their kids as beneficiaries, their neurotypical minor children as beneficiaries. And I advise against this too, Allison, because quite honestly, they're minors. So if something happens to you while these children are minors, the money is basically going to sit in trust until they turn 18. And guess what? When they turn 18, they're going to give them all the money. And it's a pretty horrible idea because most 18-year-olds, even though all of our kids are great, most 18-year-olds cannot handle large sums of money. So there are definitely better options to handle that and set that up. So if you're taking notes, the biggest takeaway of this meeting, even though it's on guardianship, is check your beneficiaries. And I'm talking about 401ks, 403bs, old pension plans, old employers, life insurance that you bought 15 years ago, anything that you can have a beneficiary on, including transfer on death or payable on death of your bank accounts. All of those things could accidentally mess you up if you have your beneficiaries wrong. And I say it's good to just double check them anyway if you haven't looked at them in a lot of years.
I agree with that. And let me add one more to the list to watch. Anyone who has teacher retirement system, TRS has a lot of options. And one thing I've seen repeatedly is an annuity payment that is left for a child with special needs. Once you die, I'm in trouble trying to help fix that. We don't have a way to change that annuity payment after you've died. You can change it with the TRS system before you die, but so that's another one to add. Just be real careful about all those payments, because I agree it's easy to mess up beneficiaries. And going back to the guardianship, what does this all have to do with the guardianship? We're talking about ways to avoid the guardianship of the estate, the expensive guardianship. And the way we avoid guardianship of the estate is make sure that money is not flowing to our children in their names. If I leave a lot of money to my daughter, Angela, is my daughter with disabilities, if I leave it to Angela in her name, first thing she's going to do is need a guardianship of the estate if she can't manage that money. Well, maybe that's not a good example. Possibly someone else could help her. But anyway, if your child is severely disabled, we don't want to deal with guardianship of the estate. We want to stick with guardianship of the person if possible. And we need to make sure it stays that way by keeping all money going to a trust, making sure a fiduciary like a representative payee can handle Social Security funds, and really being aware of what money could possibly come to our children, just like Allison recommended. Okay,
one more thing. We had something in the chat box. A lady said that her husband was getting VA benefits and the child's SSI was reduced because of the VA benefits. They're counting it as income to the child. So here's the deal with that. And we can take this offline. You can reach out to us directly. But the bottom line is if your child is under 18 and getting SSI and Medicaid, then the parental income and assets are counted. Absolutely counted if your child is under 18. If your child is over 18 and you're getting letters saying that they're reducing the benefit because of the VA benefit of the parent, it is wrong. It needs to be corrected and it needs to be appealed, and we can help you with that. And I actually saw a case like that last week where the child turned 18 like 6 or 7 months ago, and they're still reducing the SSI benefit based off of the mother's income. And then when the mom called the Social Security Administration, they said, oh yes, this is right because she still lives with you. And that is completely wrong. That is misinformation. So if that's you, wherever you fall into that category, we can help with that. And just know that there's humans on the other side of the Social Security Administration, and it is hard to deal with them, but they're they're understaffed, they're overworked, probably underpaid. They're getting like 10,000 calls a day. Like it's an enormous amount of workload that's happening, and they have turnover, and so they're training and stuff. So that's why we run into some of the problems that we do, but we can definitely help.
Yeah, and let me just add to that. Make sure that the payments are for the parent. If the payments are for the child, now adult child themselves, then Social Security will reduce. Or same thing with military survivor benefits. If your child is receiving SSI as an adult, then any income coming to them will reduce their benefit dollar for dollar. Again, even child support that's going to another parent, once your child's over 18, that's considered income to the disabled adult child. And that's where the SSI gets reduced dollar for dollar, because it is a welfare program, a needs-based program where they will look at all the income coming in. Now, it's not dollar for dollar if it's work earnings. We can get into that another time, or Allison can explain that in more detail. But that's where a special needs trust often helps, to have the military payments go to the trust, to have the child support go to the trust. Some things we cannot direct to a trust. So one of the first things you want to find out is that payment for the parent, or is the payment for the child? If it's for the child, you might have to just have the reduced SSI.
Yes, for sure. And guys, we have multiple presentations on all of these topics: SSI and Medicaid, applying for the first time, working while getting benefits. We've partnered with Andy Hardwick with Social Security Administration. All of those live on our YouTube channel. So if you've got questions deep and wide, A, you can reach out to us. B, you can, look at all of those webinars out there on the YouTube channel for that. But we definitely visit this topic on a pretty regular basis, because you're not alone. A lot of people have questions and issues with those benefits.
Okay, great. Okay, going back to the guardianship. So here we've got a slide on temporary guardianship. We just want to make the point that it is possible to have an emergency guardianship. That is what we call it, is a temporary guardianship that can last up to 60 days. But you can't just say, oh, wow, now I waited too long, I want to get a temporary guardianship. You've got to have a real true emergency for that guardianship. A situation where someone's life is in danger. I did one the other day where someone was hospitalized. I needed serious medical decisions and didn't have a guardianship. Or maybe someone is stealing all of an elderly person's money, some kind of real emergency situation. And then the temporary guardianship just lasts a couple months, and then you go and get the permanent guardianship. So guardianships are expensive. Doing a temporary guardianship pretty much will double your cost, maybe not quite double, but it will add a lot of cost. So you want to avoid that. So what you do is you start the guardianship early. If you feel like you're going to need it right when your child turns 18, you cannot have the court hearing until your child is an adult, because remember, the judge is going to find that person as an incapacitated adult. So we can't have the hearing till the child is now 18, but you could start the process 6 months early. Here's a few steps. Make sure you get that physician's form completed. On that form, there is a place where the doctor will indicate when the doctor last saw the person who's going to be under the guardianship. We call that person a proposed ward. Ward is not a very flattering term, but it's what we have in our system. So when the doctor says what day he or she examined the proposed ward, you need your application to be on file 4 months after that date. So you can't go out and get this form done years in advance. And then we would file it with the court. The proposed ward would be served by a sheriff, bringing that person, a copy of the application. Even though he or she doesn't understand what it says, they still have to be served. Other family members have to receive notice either by personal service or by mail, or they can sign waivers. This does include ex-spouses, if they are biological parents who still have rights, in other words, haven't had their rights terminated. Ex-spouses who may not even pay child support, they still have to be involved. Siblings, half siblings, there are certain family members that need to be involved. You also will need to register with JBCC, the Judicial Branch Certification Commission, and a background check will be run on you. If you have felony convictions in your past, if you have other very concerning criminal history, you may not be eligible to be a guardian. We have been able to have guardians appointed with some criminal history, but it really depends what the history is, how significant, how recent. But it is, if you have felony convictions, it's a problem. Also, any kind of issue of endangerment to a child, child pornography, those kinds of issues can cause real problems for good reason. Besides that, you will also have a attorney ad litem appointed to represent the person who's going to be under a guardianship. That attorney ad litem will come meet with your child at the house, maybe have a Zoom meeting, but will file a report with the court in some counties. In other counties, they will just give an oral testimony report. In some counties, the larger counties with statutory probate courts, we have court investigators who would also contact the family and also write a report. And again, that's county by county, depending on what type of court system there is. Once all of those things have been completed, we can have our hearings after the adult child is over the age of 18. And at the hearing, the court will make that finding of an incapacitated adult person and appoint the appropriate guardians. There are certain requirements to be a guardian. You can't owe money to the child, which seems like a silly thing, but when you deal with child support, it comes up. You can't be in litigation with your child, and you can't be a criminal, and you can't be a person of notoriously bad conduct. It's things like that. You can be co-guardians, even if you are divorced. If you are not living in the state of Texas, you can still be a guardian, but you'll need to have a resident agent. But generally speaking, parents can usually be guardians as long as they don't have significant criminal issues.
One lady asked, if my child is totally disabled mentally and physically, do I still need guardianship?
Yes, if your child is totally disabled in both ways, you definitely need guardianship, because your child would be unable to make decisions for himself or herself. They'd be unable to sign any kind of powers of attorney. So that is the case where a guardianship is probably clearly needed. Now let me say that that's not to suggest that people don't just avoid the guardianship and get by for a long time. I see this all the time with parents, where the doctors know the family, the doctors are not causing any problems, making the parents go out and get a guardianship. Where the issue comes up is when that parent dies and now there's a sibling that needs to step in. I do a lot of guardianships for siblings, because now the Medicaid waiver program or the physician or someone is saying, oh, we don't know who's in charge here, and it's time to get the court to appoint somebody. But for sure, the parents could do it ahead of time. I'm just suggesting that sometimes parents don't do it, and then it ends up siblings in a desperate rush to get it.
And I have actually seen that. I actually saw that case that in the last year, where both parents died, and they had an adult child with Down syndrome, and the brother, there was basically nothing in place. There's still nothing in place, and there's all kinds of issues as a result of that. So I actually have seen that as well. And I know that we're kind of coming down the pipe as far as running out of time. I just want to, so we talked about who's like disqualified as a guardian and things like that. The question always comes up, Allison, I know that people have to be served, okay? There has to be like this notification that somebody's filed for guardianship, and both parents have to be served. What about divorce situations where the one parent is adamantly against this? What about the parent that cannot be found, has not been in the child's life? Maybe they're out of the country, wherever they are, no one knows. What about that?
The parent has to be served. If you cannot find a parent, you'll need to get the court to make an exception. It typically involves publishing in the newspaper, showing the steps you took to find that parent. And we basically do alternative service, but you have to do something. It will probably mean a little more money spent publishing and things like that. As far as a parent who contests the guardianship, that's a parent's right to say, I don't think a guardianship is needed, or I don't think this is the right person, it should be me. And that just will complicate the guardianship, probably slow it down, may result in a hearing or mediation to work it out before you go before the judge. And you just will each present your evidence, the physician's certificate of medical examination and other evidence to show there is a need for guardianship or there's not, or this person is the right guardian, or this other person is a better choice. But yeah, parents have to be involved. I don't know if that answered all those questions. I think so. Successor guardians, with just a couple last points. Successor guardians, it's important if you are a guardian to know who will succeed you. If you are a court-appointed guardian, you should have a will that specifies who should succeed you. If you put something in your will, then the judge will look at that, and that will take preference. There is an order, which is the natural order, parents and, grandparents, siblings. If you don't think those are the right people to serve, it's especially important to get your wishes known in your will. And there's also a separate form where you can disqualify people from serving as guardians. The guardianship process is expensive. And so I wish it weren't so expensive, but it's because this system is in place really mostly for elderly people with a lot of money. That's who most guardianships are for. And so there's a lot of protections in place involving the attorney ad litem and bonds and things like that. And so it is important to plan ahead for guardianships. The guardianship is tied to a county. So if you move, you do need to transfer your guardianship to a new county. If you move out of state or into the state from another, and you have a guardianship in another state, you need to transfer your guardianship to the county where you're living, the county where your adult child is living, who's under the guardianship. Let's see, we've got 5 more minutes. I would just say, oh, right there. How do I renew my guardianship letters? Once you have the guardianship, I think I mentioned this briefly already, but if you just have a guardianship of the person, it's very simple. You fill out a report. It's a very simple form. Take a picture, explain what your child is doing, where they're living, how's their health been. Just respond to that form. You don't need a lawyer to do that. Costs about $10 in most counties to file it. And your guardianship letters, to get them renewed, they're $2 a letter. The letter is the certificate showing you're the guardian. Your guardianship letters do expire in 16 months. So the way it works is you have your hearing, and then a year later, you're supposed to do your report. The court gives you a couple months to get your report in, and then they want 2 months to get your letters out to you. So that's why it's a 16-month expiration. But you do that, but it's very simple. Again, the annual account requires an attorney every year. You need to be bonded. That's just a requirement for all guardians in Texas. Bonding can be a personal bond in a few counties. In most counties in Texas, a corporate bond is required, typically $100 a year. In many counties, you can get a one-time bond for $375. There are some counties with cash bonds of $100. So that really is county specific. Last thing, you should have court monitors who are coming and visiting your adult child. That doesn't happen in a lot of counties, but it can happen, and it's a good thing. Once you're not around, you'll be glad someone's checking on your child. Allison, I know we're short on time. You may want to wrap up, or do you have any questions for me?
I don't know if do we have more slides?
Yeah, this is just saying the guardianship can be modified or terminated. I mentioned that just briefly. It certainly is possible. I've done these types of hearings, and they're really rewarding in many cases to see someone have their rights restored. But it is a big deal. It is going to require more medical evidence, a lot of testimony, lawyers. And so, it can happen, but it's not something that's simple. But it is something important to understand, because sometimes our children need guardianships, and then with time, they might learn to be more independent. They might be able to have some of those restrictions removed. And so it is possible, again, I use the marriage example, that your child could not have a right to get married, but later on have that right restored. And so that is something to keep in mind.
Also, I just wanted to mention too, depending on the level of functioning of your child, and if you're planning on going to a college, a certificate program, any kind of other special program that you might be looking at. And we have webinars on all of the college programs offered in the state of Texas for individuals with disabilities. So there's all kinds of stuff out there. But one thing I just want you to be aware of, one question that you should be asking when you're looking at some of these programs, some of these are a hard no. If there's a guardianship in place, that your loved one will not be considered for that program. So that may be, of course, the whole state of Texas is like the most appropriate, least restrictive option is what everybody's looking for, right? But the full guardianship, there are definitively some programs out there that it's a hard no. If there's a full guardianship in place. So maybe a partial guardianship or something along those lines. Anyway, the bottom line is Allison, people like Allison, I'm an advocate of work with an attorney that is nuanced and special needs. This is not a DIY project. Don't do this yourself. Don't mess this up. Don't work with an attorney that is not specialized in special needs, that doesn't understand, because you can really make some mistakes. You can pay a lot of money. Just because you paid a lot of money doesn't mean it's right. Because I know Allison sees wrong documents all the time, and we do too. So work with somebody like Allison, work with Allison, ask these questions, but their role is really to help guide you in that right direction, to give you the tools and resources that you need to be able to make an informed decision about this, because we do know that it's emotional and it's a big deal, and this is not what we signed up for as parents. So we know that, and we're all parents here, so we've got that. But that's what Allison is trained to do, is to kind of talk you through your unique situation, really get in the weeds with you on your child and what is their functionality, what they do, what they can't do, vice versa, and then really, discuss with you what the best options might be for you. So just know that you don't call the attorney and just say, this is what I know I need. They can help you. You don't have to know everything.
Thank you. Yeah, I agree with all of that. I'm seeing names I recognize in the chat. It's fun to be here. And by the way, I will just also say, if you feel a little overwhelmed with this decision, I understand it. It is very emotional, as Allison alluded to. And I mean that sincerely. If you just need someone to bounce off your individual child's situation, just kind of talk it through, you're more than welcome to call me. That's a sincere invitation.
So I know that we're out of time, and so just give people a broad range. I know if it's contested, it's a lot more, but if people are trying to plan financially, they know they're going to need guardianship. Give them a range of if it's not contested, what a person might expect to pay from a guardianship perspective, because inquiring minds definitely want to know, Allison.
Yeah, I would say attorney's fees will typically be at least $2,000, probably more like $2,500. In most places across the state, it's probably $3,000 or up. There are some counties that have programs. If you are below the poverty line, you can typically get some court costs waived. Well, you can get court costs waived in most counties, in our area, Catholic Charities. But if you get the right lawyer, I try to keep my fees the same as Catholic Charities for a situation like we're on today, where we deal with parents. It's not a complicated situation, but I would say the court cost typically will be $1,000. Again, it's going to be county specific, but my best estimate, as I'm rambling here, is around $3,500 to $4,500 to get a guardianship.
And I've seen, I would say what I've seen, and this is dealing with all across the state, not just in one particular area, is anywhere from 25,000 right on up to $6,000, and if it's contested, then all bets are off, and it could be a lot more. But so for that, at least you can kind of plan, a little bit, financially to think about those things. Guys, our consultations are always free at Consolidated Planning Group. So if you have, a unique situation or unique, scenario that you want to talk about, you can use this QR code and you can get on our calendar. You can schedule and get on our calendar. Our YouTube channel and our Facebook page is out there. We mentioned that a couple of times. And oops, I think I had one more. I think I missed it. Let me get back to Allison's contact information as well. And you can reach out directly to her. And then in the email with the slides, you're going to get a copy of the slides, you're going to get a copy of the recording, and you're going to get everybody's contact information, so you don't have to write this down super fast before we go. So, Veronica, we went over, sorry, only by 3 minutes. Sorry for that. We really try to get done right on time at 1 o'clock, but we had a lot of good questions, and this topic is so important. So thank you again for having us. And Allison, such a pleasure to work with you again on this. It's such an important topic, so I'll look forward to partnering with you again soon.
Thank you. Feel the same.
Thank you, ladies.
Thanks.
Thank you,
Thanks,
everybody.
everyone.
Bye.
Everyone have a great afternoon. Take care.
You too.
Bye-bye.
The recording.